lenders often have a question because they've heard the term but aren't really sure what it means, the right of redemption. So what is the right of redemption? The right of an owner to reclaim property lost or in jeopardy of being lost to a mortgagee by paying off the debt the property secures. After the borrower's default, the mortgage and the note are our tickets into court. The suit is the vehicle to enforce the security instrument, but the object of the suit is to extinguish the owner's right of redemption. So as I say there, what we do is we foreclose the owner's right of redemption and thereby take clear title to the collateral real estate. So one way to think about a foreclosure action is as a quiet title action. My colleagues in Georgia and Tennessee can fill you in on non-judicial foreclosures, but my impression, being pretty ignorant of those, is that the right of redemption in those states is extinguished without much more than the thought that it should be extinguished occurring in the mind of a banker, and then someone shows up at the house with a chain of keys. Does that pretty much cover it, right, Erica? Yeah. It's a different story in judicial foreclosure states. They require a mortgagee to file a lawsuit. In Indiana and Kentucky, judicial foreclosure states, the foreclosure lawsuits are strange creatures that amount to a slow motion, coerced real estate transaction between at least two unwilling parties, supervised by a court but conducted by a county official. In Indiana, the sales are conducted by a county sheriff, and in Kentucky, they're conducted by a master commissioner. Master commissioners in Kentucky fulfill their duties according to the court rules. So each circuit, and there are 57 in Kentucky, appoints a master commissioner. Court Rule 53 goes on to provide that judicial sales under an order of judgment of the circuit court may be executed by a master commissioner under such terms and conditions as are specified by the circuit court, either in its order or judgment or by rule. So local rules govern master commissioner practices in Kentucky unless they don't. Because like politics, foreclosures are all local. Some circuits have very specific language, like Jefferson Circuit Rule 505 that must be in the judgment, or some have specific formatting questions for which you'll get dinged if you ignore them, like Grant Circuit Rule 2G. In any event, it's essential that your attorney speak with the commissioner's assistant at the beginning of the case and then during the sale process, because she's likely to be the keeper of all useful knowledge during the case. Jefferson Circuit Court, for instance, has a master commissioner. This is just to show how among the 57 circuits, things vary wildly. The master commissioner, Edith Hoblev, has 6 deputy master commissioners and extensive local rules, 16 of them. Kenton County, on the other hand, has a master commissioner, no local rules, but again, you proceed at your own peril if you don't talk to the commissioner's assistant, Linda, first. To give you a flavor of how these go in one circuit, in Jefferson Circuit, I'll say something about the process there, which is charitably characterized as unique. In Jefferson Circuit Court, lien enforcement actions are automatically referred to the master commissioner, who acts essentially as a magistrate to the circuit judge. In other counties, as this slide says, there are other ways to get the referral made, either by an order tendered with the motion, an automatic referral, or by filing an administrative office of the court form. After the referral is made, the commissioner reviews the file. In Jefferson County, the master commissioner, the deputy master commissioner, also conducts hearings when necessary if the foreclosure is disputed, reviews the motion for judgment order of sale, and makes a recommendation to the circuit judge regarding whether the judgment order of sale should be entered. The commissioner, as I said, also conducts the judicial sale. The way this works in practice in Jefferson County is that the case is referred to the master commissioner through notice under local rule, and the file is hand carried or pushed on a cart to the commissioner's office and placed on a shelf for review in the order in which the files come in. And to give you an idea, there are over 200 foreclosure sales set every 2 weeks, so it's a pretty big shelf. The master commissioner then reviews the record, finds a nit, collects $50, and returns the file by hand to the circuit court clerk. Then the attorney gets notice of that, removes the nit, renews the motion for judgment, which stands automatically referred to the commissioner. It doesn't have to go back to the judge, and it doesn't require a motion hour. But the file is carried from the circuit court clerk back to the commissioner's office for a second review. Then the commissioner reviews the record again, recommends judgment, hopefully, with notice to any other party for objections. That's a 10-day period. If no objections are filed, then the file is walked not to the circuit clerk's office, but to the judge's office in his chambers or her chambers for signature. Then the file is hand carried to the circuit court clerk for entry of judgment, and the file winds its way back to the commissioner's office to await sale. Commissioner's sales in Jefferson County are set 8 to 12 weeks out from the date that the commissioner sets a sale. That's immediately followed by the senior partner on the file complaining about the delay. Then I spend the next 8 to 12 weeks begging the client for bid instructions, sometime between 6 p.m. the night before and 10 a.m. on the morning of the sale, which begins at 10. The client provides bid instructions or decides to cancel the sale. In Indiana, the process is much more streamlined. There you move the court for judgment, usually get a judgment. You file a precipe. That's a fancy Latin word for a request for a sale date. The sheriff sets the sale. The plaintiff drafts all the necessary documents, the deed, the foreclosure, sale notice, and the sales disclosure form. You get a sale, and it takes just as long. It's streamlined, but just as slow. At the end of both of these drawn-out procedures, however, is the sale, and that's the true mechanism by which the borrower loses the right of redemption. How exactly the sale does that and deprives the borrower of the right of redemption differs. In Indiana, the right to redeem the property from the foreclosure judgment terminates with the sheriff's sale. That is, the owner must pay the entire debt before the sale or the disposition of the property. And that question's been litigated, and the current chief judge of the U.S. Bankruptcy Court for the Southern District of Indiana, Jim Cochise, has concluded in Collins that a sheriff's sale is complete when the hammer falls. So that's the moment at which the debtor loses his or her right to pay off the bank's debt and take the property back. Even though some states may permit redemption post-sale, Indiana is not one of them. Kentucky is. In Kentucky, the right to redeem terminates only if the sale brings more than 2/3 of the court-appraised value. In irony-laden language, the KRS requires that the appraisal be made by 2 disinterested, intelligent housekeepers of the county. If the winning bid does not bring 2/3 of the appraised value, the defendant can redeem it. That is, it'll be the winning bidder will receive a commissioner's deed that provides that the transfer's title is subject to the prior owner's right to pay the winning bid, not the judgment, but the winning bid amount, plus 10% into court within 365 days of the sale date. So in Indiana, to recap, prosecute the foreclosure action through the sheriff's sale. The bid should be formulated, therefore, to maximize the deficiency, but to avoid a contest as to whether the bid is so low that it will shock the circuit judge's conscience. So Indiana, there's no minimum bid as there is in Kentucky. some bankers worry that, well, should I at least bid fair market value, whatever that is. The Supreme Court taught us in BFP versus Resolution Trust that fair market valuation presupposes conditions that by definition don't obtain in a forced foreclosure sale. So that's not applicable. So rather the standard is, and it's a squishy one, whether the bid is so low as to shock the judge's conscience. But there are market forces in play there that also will, usually occur in the form of foreclosure vultures who will be at the sale and outbid an extremely low bid by the bank. So that'll ensure that the shock the conscience standard really is an issue. As I said, in Kentucky, you have to prosecute the foreclosure sale. The minimum bid that the bank should make, unless there's a very good reason not to, and then you still shouldn't do it, bid below 67% of the ceiling, 67% of the appraised value. Not 2/3, because that's what the statute says, and that's an invitation to litigation or at least a hearing. 67% removes all doubt. And the ceiling, on the other hand, is whatever you want it to be. But at most, it could be is the bank's debt, interest, and chargeable costs as of the date of the sale. So don't forget to check that your attorney has included both pre-judgment and post-judgment interest through the date of sale, because the judgment should provide that continues to accrue until the date of sale. And so that gives you more room with which to credit bid and get the property. So that's foreclosures. Any questions about foreclosing the right of redemption in Kentucky and Indiana?
Does the redemption rate start running whether it's IRS or borrower's redemption from the date of sale or the date of release?
The United States Code provides two government rights of redemption, and I get them confused. The IRS either gets 180 days or a year, I forget which, and all others get the opposite. And those dates, as far as I'm aware, run from, like the state law redemption period, from the date of sale. Those can be sometimes negotiated away because for practical purposes they're often valueless to the United States, but leave a cloud on the title for a bank who's taking it REO, or for a third-party purchaser who was so lucky to buy the property at the sale. I'm going to turn it over to you guys because we only have 20 minutes left, and I want to make sure you have time. If there's time at the end, I'll be happy to take more questions. Or
I extended it till 12:30.
okay, then I'll be happy to continue. Lucky you. So on to the heartburn portion of my presentation. I'm going to talk about keeping guarantees valid against guarantors during the life of a loan in Indiana and Kentucky. Kentucky and Indiana guarantee laws are designed to protect banks, no, guarantors. As we'll see, Indiana is slightly more lender friendly, but as a practical matter, and for most of the people in this room's purposes, guarantee law, like bankruptcy law, is borrower oriented. Kentucky's guarantee statute establishes the requirement that if a guarantee is not written on the note or expressly refers to the note, then it must state the maximum principal amount of the liability, not including attorney's fees and costs, and the termination date. So repeat, if it's not on the face of the instrument, it has to expressly refer to that instrument in detail by citing the amount and the loan number, or it has to state the amount that for which the guarantor is on the hook and the date certain on which it expires. That way, the guarantor knows how much and for how long she's on the hook. Indiana doesn't have that kind of statute dictating guarantee terms at the front end of a loan, but if the underlying obligations on an Indiana loan change during the life of the loan, and after the guarantee contract is executed, then depending on the circumstances, the guarantor may be off the hook. So Indiana case law provides that when parties cause a material alteration of an underlying obligation without the consent of the guarantor is discharged from further liability, whether the change is to his or her injury or benefit. So, two elements there, a material alteration and without the guarantor's consent. A material alteration, according to the case law, is that which will affect a discharge of the guarantor. It must be one that includes a change which alters the legal identity of the principal's contract, or substantially increases the risk of loss to the guarantor, or places the guarantor in a different position. This last one obviously swallows the exceptions because arguably any alteration of the credit terms also alters the guarantor's position too. This is just an invitation for guarantors counsel to litigate, and it's also an insurance policy for guarantors counsel against Rule 11 because anything conceivably and plausibly could change a guarantor's position. So the theme is litigation costs versus preventative medicine. Given Kentucky's rule establishing the amount and length of the guarantor's obligation on the front end, and Indiana's rule that practically any change in the terms to which the guarantor does or not simultaneously consent on the back end, both laws should lead you to insist on new guarantees or acknowledgments of the continued validity of guarantees whenever a note is modified. As I said, Indiana courts are a little more lender-friendly in applying this law, but the theme remains the same, litigation costs versus preventative medicine. In the district court case in 2006 in Indiana, Selmer versus Bamber, Selmer Company was the lender. The defendant borrower was Woodwind, and the defendant guarantor was Bamber. After the execution of the underlying security agreement and guarantee, Selmer Company's ownership changed several times. The owner defaulted and sued Selmer. Guarantor Bamber did not dispute execution of the personal guarantee at the front end or its terms or conditions. Rather, he argued that since the liabilities under the security agreement changed over time, he was relieved of liability under the guarantee. The district court in its decision restated the basic rule that I mentioned before, that when the principal and obligee cause a material alteration of the underlying obligation without the consent of the guarantor is discharged from further liability. In that situation, Bamber was compelled to provide evidence in his defense of the material alteration was without his consent. Unfortunately for him, the evidence showed that Bamber was simultaneously fulfilling both roles as an obligee on the debt in his professional role as head of the borrower and as a guarantor under the ongoing security agreement. As principal of the borrower, therefore, Bamber was unable to prove that any material alteration of the underlying obligation was without his consent so as to discharge him from personal liability. So the lender won. But even though the lender prevailed, and there are plenty of other cases that provide the same lesson, having us, preferably us, litigate is expensive. So the moral is, if as a lender you intend to refinance or modify a deal, each and every party that you want to answer for the debt should sign off on the new loan documents each and every time. This is particularly true if you're materially altering the original obligation. get the guarantors to sign another guarantee or get the accommodation party to sign a note modification. You should take the view that it's an entirely new transaction. Even if the original documents have savings clauses or future indebtedness clauses, those are litigation traps. Though there's pain and it's cumbersome to trot these folks into the office and have them sign new guarantees, it'll be worth the effort, and you could save years and thousands of dollars on the back end.